Okay, thank you very much for joining. As I explained on Thursday evening, during the Thursday evening class, I'm going to do a short class this morning, just sort of the first half of the unit on auditors, external auditors. Then we can finish the unit on Tuesday, and you use Thursday as a revision class to prepare you for your quiz, which is set for next week on Saturday, test 2. So this unit is about external auditors. You're all accounting students. You should know what external auditors are. External auditors play a very, very important role in companies, in practice and legally in terms of the Companies Act. To help you to understand this, this is all still part of the division of corporate functions, the separation between the two organs of the company. Your board of directors on the one hand, and your shareholders, your owners, on the other hand. The shareholders own the company, but the directors manage their property. Shareholders, if they're not also directors, are not directly involved in the running of the company. So your directors have a fiduciary duty to manage the property of the shareholders to the best of their ability. But obviously, because of the separation between ownership and control, there have to be certain safeguards so that the shareholders can at all times be assured that the directors are not up to any funny business, that their property is being managed for the best interest of everybody involved, to the best interest of the company. If the directors act to the best interest of the company, that will obviously also be to the best interest of the shareholders. I did pick up when I was marking test 1, those marks will be released before the end of the weekend. When I was marking that there are still some students that don't quite understand this division of corporate functions. They don't seem to understand what directors are. And on the other hand, what shareholders/members are. There was a question, one of the short questions, how do you become a member of the company? And far too many students told me by being appointed as a director. No, being appointed as a director does not make you a member of the company. And also in, what was it, question 3, the one about division of corporate responsibilities, corporate functions. Some students told me that the shareholders must act in their own best, or the shareholders might act in their own best interest. The shareholders don't act. Shareholders don't manage the company. The directors do, not the shareholders. Remember that. Get that straight. But to protect the shareholders, the Companies Act has numerous provisions, essentially detailing how the directors must do their job. And a very important one of these is the fact that all companies are required by law to have external auditors. Many companies, especially your larger companies, also have internal auditors. We're not talking about those. Those are employees of the company. We're talking about external auditors. Let me just share the PowerPoint. Can you all just keep your microphones muted? Okay, just give me a thumbs up if you can see the PowerPoint. Thank you, Mr. Mdadi, Mr. Tony. Okay, so let's get started. Your learning objectives, remember to always go back to them. So, as I've started explaining in my introduction, the Companies Act requires all companies at all time to have an external auditor. These external auditors play a very, very important role regarding the compulsory disclosure and transparency that is required in terms of the Companies Act. Companies Act also requires of external auditors to have a high level of professional competence and to be independent. So those are two requirements to be appointed as an external auditor: professional competency as well as independent. So let's just clarify some terminology here. In the course of this unit, I might use the term that the external auditors are employed by the company. If I say the external auditors are employed by the company, that means that there is a contract between the company and the external auditors for the external auditors to do an annual audit. Employed by the company does not mean they work for the company. It does not mean they are salaried by the company. This is not a relationship which is dictated by the Labour Act. The term employed by, in the sense or used in the context of external auditors, merely means that these external auditors have been appointed by the company to perform the annual audit. So first of all, who may then be appointed as an external auditor? Companies Act does in fact not say who may be appointed. It uses the same approach as it does with directors, namely who may not be appointed. So certain categories are listed who may not be appointed. If somebody doesn't fall in this category, it implies that they may be appointed. So who may not be appointed as an external auditor? Firstly, any director, officer, or employee of the company. While we're going through this list, bear in mind the underlying requirement: professional competence and independence. Oops, sorry. Let's firstly go right to the bottom. This very last bullet point addresses the issue of professional competence, namely that nobody may be appointed as an external officer, an external auditor, sorry, if they are not qualified to act as such under the Public Accountants and Auditors Act. In order to be appointed as an external auditor, they must be a chartered accountant. That does, of course, not imply that the chartered accountant may not have clerks or audit managers or whatever to assist them, but the person that must be appointed must be a chartered accountant. Doesn't have to be an individual. It normally is not an individual. You don't appoint Johnny as external auditor. These auditors work for a firm of auditors, and it is the firm that is appointed. But of course, the partners, audit managers in this firm must be qualified chartered accountants in terms of the Public Accountants and Auditors Act. So that addresses professional competence. With regard to independence, these other bullet points address independence, independence, that this person or this firm must be independent of the company. First one, that's fairly self-explanatory, a director, officer, or employee of the company. Director means both executive director and non-executive director. Chartered accountants are often very much sought after to serve as non-executive directors of companies because of their financial and business expertise. But if you are serving on the board of the company, you may not also be the external auditor. So you have to choose, do you want to be on the board or do you want to be the auditor? Second bullet point, a director, officer, or employee of any other company performing secretarial work for the company. By secretarial work, I don't mean the ladies that do the typing. Talking about the company secretary. All companies, in terms of the Companies Act, there's quite a large amount of annual returns that have to be filed, etc., done by the company secretary. The company secretary is normally either somebody with an accounting degree or a law degree. Many larger companies have full-time company secretaries. Smaller companies, it might not be affordable to have a full-time person performing this company secretarial work. Then there are other businesses that do company secretarial work. But the company secretarial work and the external audit must be held separate. So no director, officer, or employee of any other company that does company secretarial work for the company may be the external auditor. Third one, a partner or employer or employee of a director or an officer of the company. This relates to what I've said earlier about non-executive directors. So let's say, let's use an example here. Let's say Justice, Evelina, and Eben are all chartered accountants. They have work as partners in a firm of chartered accountants. But now Justice is serving on the board of ABC Company as non-executive director. That means his whole firm, including Eben and Evelina, may not be appointed as external auditors of ABC Company. So they can't argue, well, it's Justice that is on the board in his personal capacity and Evelina will be doing the external audit. The fact that they are partners in an auditing firm means that entire firm is excluded. This one is similar to the previous one. A person who personally or whose partner or employee habitually or regularly performs the duties of secretary or bookkeeper of the company. So it's not just company secretarial work, it's also if you employ somebody from the outside to do the accounting functions, the bookkeeping functions. You also cannot avoid this by deciding, oh, well, you're going to resign as director so that your auditing firm can be appointed as external auditors. A person who at any time during the financial year was a director or officer of the company. So if Justice suddenly decides he's going to resign, step down as non-executive director, that still doesn't imply that his audit firm can now become external auditors. They will have to wait until the next financial year. So all of those provisions relate to the independence of the external auditor. Companies Act makes an exception for private companies. Namely, if the company is a private company, they may appoint a person who performs duties of secretary or bookkeeper of the company. So it refers to that provision. Oops, sorry, that's not what I wanted to do. That's what I wanted to do. So the Companies Act makes an exception with regard to that particular provision, specifically for private companies. And I'm warning you now, if you get a question in your quiz in test 2 on Saturday about who may be appointed as external auditor, this is another one of those cases where you have to take note, you have to be cognizant of what type of company this is. I'm not going to tell you Okathimeti Pty Limited, which is a private company. I'm just going to say Okathimeti Limited or Okathimeti Pty Limited. And you need to know, private or public, does this exception apply or not? There is an exception that people that form in this category may be appointed, provided they meet the competency requirements, that they are a registered chartered accountant. All the shareholders must agree in writing to their appointment, and the relevant circumstances must be set out in the auditor's report and the annual financial statements of the company, so there must be disclosure. As I've mentioned, in most instances, it is not an individual, a single person, which is appointed as external auditor, but it is usually a firm of auditors that is appointed. KPMG, PwC, EY, Grant Thornton, whatever. So not Johnny or Susie or Peter, but the firm of accountants. Firm of accountants may be appointed, usually is the case. What will happen if there is a change in the composition of the members of the firm that has been appointed? Remember, just to put this in context, you learned when we did partnerships, you learned that if a partner resigns, the partnership terminates. You also learned that that is actually just theoretical, because the remaining partners may immediately form a new partnership and continue practicing under the same name and style. If there's a change in the composition of the members of the firm, one of the partners resigns, this will not result in a casual vacancy in the position of external auditor. Going to get back to the concept of a casual vacancy shortly. Unless less than one half of the members remain. So if there were 4 partners and 3 of them resign, then it will be taken as a resignation of the auditor and it will result in a casual vacancy. But if it is just 1 out of the 4 or 1 out of 10, it will not affect the appointment of that firm as external auditor. So when is the first auditor of a company appointed? First auditor of the company is appointed when the company is registered. When you register a company, you must actually also submit a document whereby the first auditors accept their appointment as external auditors. If the external auditors are not appointed when the company is registered, the directors of that company must appoint the external auditors within 21 days. If after 21 days an external auditor has not been appointed, then the registrar of companies is empowered to appoint an external auditor. These 2 bullet points are actually, although they are in the Companies Act, are actually purely theoretical, because the Register of Companies, BIPA, will not register a company if that document, the acceptance of appointment by the first external auditors, are not submitted. This first auditor is then appointed until the first annual general meeting of the company. So the first external auditor serves until the first annual general meeting. The Companies Act also provides that a company must appoint an auditor at every annual general meeting. Appointment of the external auditors is part of the standard agenda for every annual general meeting of every company. The external auditor then holds office, remains appointed until the next annual general meeting. So a company cannot fire their auditor or replace their auditor, dismiss their external auditor between annual general meetings. There are some exceptions to that. We're going to get to that later. But in general, auditor is appointed at the AGM, remains so appointed until the following AGM, cannot be dismissed in the meantime. Companies Act also provides that the external auditor is deemed to be reappointed at every AGM. So, although it's a standard agenda point of an annual general meeting, it is usually merely a confirmation that the current external auditors are reappointed, unless they are either not qualified for reappointment or at the AGM, a special resolution is adopted appointing somebody else, a different different external auditor. Or if the existing external auditors have given notice in writing both to the company and the registrar that they are unwilling to be reappointed. Should it so happen that the existing external auditors are not reappointed and there was no special resolution appointing somebody else, or they've given notice that they're not willing to be reappointed and they haven't been replaced at the AGM, the directors or the registrar may then appoint external auditors within 30 days of the date of the annual general meeting. So just to recap this, at every annual general meeting, essentially the current external auditors are reappointed then for a period up until the following annual general meeting. They cannot be dismissed during that time. They cannot be replaced between the annual general meetings. They can only be replaced at an annual general meeting by way of a special resolution. So majority of shareholders. Look at this from the point of view that it's a special resolution. It is the shareholders, not the directors, the shareholders that appoint the external auditors, because the job of the external auditor is to look after the interest of the shareholders, not to look after the interest of the directors, the interest of the shareholders. It is the shareholders that appoint them at an annual general meeting. And next time the shareholders will be convening will be at the following annual general meeting. And in the meantime, the directors cannot fire and replace these external auditors that were appointed by the shareholders. That doesn't mean, as an external auditor, that you are stuck. The directors may not fire you. The directors may not terminate your appointment. But you do, however, have the right to resign at any time that you wish. So you don't have to wait till the annual general meeting to resign. If the external auditor resigns at any time during their period of office, they have to file a written notice to both the company and the registrar of companies that there is no reason to believe that there have been any material irregularities, or if there was an irregularity, such irregularity has been reported. If the external auditors resign during any time between annual general meetings, this will give rise to what is known as a casual vacancy. If a casual vacancy arises, the directors can and must replace the external auditors within 30 days, failing which the registrar of companies will make an appointment. So the only time where the directors may appoint the external auditors is between annual general meetings, if the auditor has resigned and there is a casual vacancy, they then have to fill that vacancy. So going back to this slide where I pointed out that the external auditors are deemed to be reappointed at every annual general meeting. What if the shareholders decide to replace them? The procedure, the prescribed procedure that has to be followed is that this can only be done by way of a special resolution at an annual general meeting. If the intention is to adopt this special resolution, special notice must be given. Go back to Unit 8. What is special notice? Special notice is 28 days. Your normal notice period for an annual general meeting is 21 days. If part of the agenda of that annual general meeting is the removal of the external auditors, special notice, 28 days notice must be given. Special notice must also be given if the intention is to remove the directors. The external auditors that stand to be removed must be allowed to make written or oral representations to the shareholders. And then a special resolution is required to remove them. So make sure you've got this straight in your head. Removal of directors requires special notice, but an ordinary resolution. Removal of external auditors requires special notice and a special resolution. There is, however, an exception to this provision that under certain circumstances, an ordinary resolution will be sufficient. This is in the event where the external auditors were appointed by the directors. So let's go back. If there was a casual vacancy, the directors have the right to appoint external auditors. But the shareholders then have a right to remove those auditors that were appointed by the directors. They don't have to wait until the following annual general meeting. It can be at any general meeting, and an ordinary resolution will be sufficient. But you must still give 28 days notice. You must still give special notice. If the shareholders choose to so remove these external auditors, they have to replace them at the same meeting. Is everybody clear about this? Thank you, Evelina. Thank you, Ms. Ndadi. Just to run over it again quickly. External auditors. Purpose of external auditors is the protection of the shareholders. Shareholders appoint the external auditors at an annual general meeting, and they can only be replaced at the next annual general meeting. If, however, they have resigned and the directors appointed external auditors and the shareholders are not happy, they can step in and then call for a meeting to replace them, and then only an ordinary resolution will be required. This is all just to make it easier in your heads to understand this. This is all geared at the protection of your shareholders. So if the directors have been doing funnies and want to appoint an external auditor that they know is going to keep quiet about this, the shareholders will have the right to step in and replace those and appoint them with properly independent external auditors. So it's not that difficult to understand if you remember what the rationale, the thinking behind all of this is. Okay, next is rights and duties of the external auditors. I don't normally do that in too much detail. And then liability of the auditor. I'm going to stop here for today. This is essentially what I wanted to do, just to give us a little bit of headway. Who may be an auditor, how are they appointed, and how are they removed? Any questions? No questions. Thank you so much for giving up your Saturday morning. Wasn't that long. I hope it was worthwhile. That's given us a little bit of breathing space for Tuesday. Enjoy the rest of your weekend. If you're traveling anywhere, please stay safe. Thank you. Bye.